Hi all, welcome and welcome back to my channel. In this video, I'm going to share quite the story with you that begins with a very disturbed young man and ends with a father of three behind bars, charged with 4 counts of first-degree murder. Not gonna lie, this story's messed up from start to finish, so I'm not even gonna try to make it make sense. Consider yourself warned. Here we go. According to police, 2 families shared a duplex in Kellogg, Idaho. One family lived there for a while, and one family had just recently moved in. The Kellogg police reported that they received a call to the home in early June of 2023, stating that one of the members of the family that had recently moved in, 18-year-old Devin Smith, stood in his bedroom window and exposed himself as the mother and the children of the other family played in the backyard that the family shared. The mother of the children posted about what Smith did to her and her children that day on Facebook. Her post read, "So we got new downstairs neighbors 2 weeks ago. They have 2 teenage boys. One just graduated and the other one does next year. We share a backyard. My kids stay on their side, but they're out there a lot. They jump on the trampoline with the sprinkler. Almost every single time, the older boy goes outside on his porch and seems to be watching them. I tried to brush it off since it's their yard too, but my mama gut couldn't shake it. I was outside with Emery and Ellie coloring with chalk in our backyard tonight when Emery says, 'Mom, the boy is in the window,' and she seems shocked. I say, 'Yes, it's their house. It's fine.' And she goes, 'No, Mom, the boy, he's shaking his penis.' The dude was staring out the window directly at my girls and I and beating his you-know-what off. I saw his naked body jump up on his bunk bed and scoot back. I made an effort to not look in their windows, so the fact that he was standing right in front of it and my daughter saw everything is absolutely disgusting. Especially because she was on the opposite side of our climbing dome, as far away in the yard as she could be on our side, not even close to his window. Why were you staring in their direction? I immediately ran to get Major, who went down to go bang on the window. He was gone, so Major went to the front door and had to knock several times before he got an answer. I am freaking distraught. I'm already so uncomfortable living here, and now this. I called the landlord to let him know in case they start trying to complain about us, or if they want to try to start drama and get us kicked out, so he knows why. I am livid. The police have been called. I don't take stuff like this lightly. I just want to protect my children, but people always act like you're being dramatic. This is the last thing I want to be dealing with in this market. Now my kids can't play outside like they've been able to for years when there was just a sweet old lady living below us." Police said they responded to the call, investigated the call, and a report was done that day and submitted to the prosecutor's office for charges. They say they recommended that Smith be charged with indecent exposure. Then, just days later, on June 18th, police said the children's father, Major John Kaler, arrived home from work, got his handgun, and went outside into his backyard to water plants when he got into an argument with Devin Smith's mother and grandfather about Devin's disturbing behavior. The fight escalated, and Kaler started shooting. He shot both Kenneth and Kenna Gardapi dead in their backyard. Then, police said he went into Devin Smith's home and executed both Devin and his 16-year-old brother, Aiken. He killed them all. Police said they responded to a 911 call that someone was shooting their neighbors and found all 4 people dead, shot at point-blank range. Then they found Kaler's gun with blood on it in a truck in their driveway. Kaler was arrested, and police said he told them he tried talking to Devin's mother and grandfather about his behavior, but they didn't seem to take his accusations seriously enough, So he told him he snapped and did something about it. Because he confessed to the killings, he's being held without bond. His preliminary hearing is set for July 3rd. I'm going to play Kaler's first court appearance next for anyone who would like to watch it. Otherwise, I don't know what to say, other than to thank you for watching. You know I appreciate you. Stay safe out there, and here is his hearing.
All right. You may be seated. Thank you. Good morning. We're on the record in State of Idaho versus Major John Kaler, Shoshone County case number CR 40-23-970. This is the time set for a first appearance in this case on a 5-count criminal complaint. Mr. Kaler is present with counsel Ms. Cheesebro, Mr. Allen, and Ms. Jacobs on behalf of the state. Mr. Kaler, I'm going to start by going over with you your rights in a criminal case. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to represent you at public expense. How would you like to proceed with respect to your attorney appointment? You have submitted an application for court-appointed counsel, sir.
I'd like to get a public defender.
Based upon a review of your application for court-appointed counsel, I did determine that you do qualify based upon your income status. I will appoint an attorney to represent you. For purposes of the first appearance here today, Ms. Cheesebro is a qualified individual who is listed on the Public Defense Commission roster as well as a qualified felony counsel. She is appointed for purposes of your first appearance today and may or may not remain your counsel depending upon the need to appoint capital qualified counsel within the next 14 days. You are presumed innocent until proven guilty, sir. What that means is you have the right to a jury trial. At that trial, the state bears the burden of proof beyond a reasonable doubt as to every element of the offense charged. You have the right to a preliminary hearing. At that preliminary hearing, the state bears the burden of proof to show by sufficient evidence that more probably than not a felony crime has been committed, and more probably than not you committed that offense. If the court finds probable cause after a preliminary hearing, it will sign an order binding you over to the district court. Once you are bound over to the district court, at that point in time you will have an arraignment at which you can enter a not guilty plea. At any jury trial or hearing, you have the right to testify or not testify. If you choose not to testify, that fact cannot be used against you at trial. You have the right to confront and cross-examine any witnesses that are called to testify against you, and you have the right to call your own witnesses and the right to compel witnesses to testify by way of a subpoena at no cost to you. If you are convicted or plead guilty, you have the right to appeal that conviction and sentence. Do you understand these rights, sir?
Yes.
The next issue I will go over with you is the criminal complaint. Ms. Cheesebro, did you receive a copy of the criminal complaint?
We did.
Did you have an opportunity to go over that with Mr. Kaler?
We have.
Mr. Kaler, count 1 charges you with a violation of Idaho Code 18-4001, 18-4002, 18-4003, murder in the first degree of felony. That offense alleges that on or about the 18th day of June, 2023, in Shoshone County, state of Idaho, that you did willfully, deliberately, and with malice aforethought unlawfully kill the person of Kenna L. Gardapi, a human being, to wit, by shooting her, which resulted in death, and which was premeditated and/or to execute vengeance. That carries a potential maximum penalty of death and/or life imprisonment. Do you understand that charge and the potential maximum penalties, sir?
Yes.
Count 2 also charges you with murder in the first degree, a felony, violation of Idaho Code 18-4001, 18-4002, 18-4003, murder in the first degree. It alleges that on or about the 18th day of June 2023 in Shoshone County, state of Idaho, that you did willfully, deliberately, and with malice aforethought unlawfully kill the person of Kenneth R. Gardapi, a human being, to wit, by shooting him, which resulted in his death, and which was premeditated and/or to execute vengeance. That offense carries a potential death and/or life imprisonment. Do you understand the charge and the potential maximum penalties for that count?
Yes.
Count 3 charges you with a violation of Idaho Code 18-4001, 18-4002, and 18-4003 A and D, murder in the first degree, a felony. It alleges that you committed that offense on the 18th day of June 2023 in the county of Shoshone, state of Idaho, by willfully, deliberately, and with malice aforethought, unlawfully killing the person of A.S., a human being, to wit, by shooting him, which resulted in his death, and which was premeditated to execute vengeance and/or committed in the perpetration of burglary. That carries a potential maximum sentence of death and/or life imprisonment. Do you understand that offense and the potential maximum penalties?
Yes.
Count 4 charges you with a violation of Idaho Code 18-4001, 18-4002, and 18-4003 A and D, murder in the first degree, a felony. It alleges that you committed that offense on the 18th day of June 2023 in the county of Shoshone, state of Idaho, by willfully, deliberately, and with malice aforethought, unlawfully killing the person of Devin R. Smith, a human being, to wit, by shooting him, which resulted in his death, and which was premeditated to execute vengeance and/or committed in the perpetration of burglary. That carries a potential maximum penalty of death and/or life imprisonment. Do you understand the maximum penalties in the charge, sir?
Yes.
Count 5 charges you with a violation of Idaho Code 18-1401, burglary, a felony. It alleges that you committed that offense on or about the 18th day of June 2023 in the county of Shoshone, state of Idaho, by entering into a house, room, and/or apartment with the intent to commit the crime of murder. That carries a potential penalty of not less than 1 year in prison and a maximum penalty of 10 years and a $50,000 fine. Do you understand that charge and the potential maximum penalties?
Yes.
A preliminary hearing needs to be set in this matter. Ms. Cheeseborough, have you had an opportunity to discuss the time frame for that preliminary hearing with your client?
Your Honor, we're going to ask it to still be set within the 14 days at this juncture.
At this point in time, the court will set the matter within the 14-day minimum time requirement. I will set that matter for July 3rd, 2023, with an 8:30 a.m. status conference and a 1:30 p.m. preliminary hearing if the matter proceeds to preliminary hearing on that date. We will send out notice to that effect. The next issue we intend to address is the issue of bail or release. I will first hear from the state. Mr. Allen.
Thank you, Judge. Your Honor, first I'd like to start by pointing the court this morning to Idaho Code 19-2903. Under 19-2903, this court has the discretion to analyze the factors applicable in this case and determine if bond or bail is even appropriate in this instance. To that point, Judge, I would defer to the court's discretion, as the court ultimately has discretion under that statute and has the ability to make determinations necessary therewith. Under Idaho Criminal Rule 46C, Your Honor, factors are outlined for this court to consider in determining if bail is set, what an appropriate bond amount should be, and any associated conditions with that bail. Pursuant to Rule 46C, I'd like to highlight for the court some of the factors under that rule that I believe are most applicable to this court's determination here this morning. Starting first with ICR 46C1, the employment history and nature of employment of the defendant is of pertinence to the court's consideration. Based upon information received by our office in anticipation of this morning's proceeding, it appears as if the defendant, both through statements made, through information gathered, and through the application for a public defender submitted to this court, the defendant has lawful employment with a local business working as an underground miner, and as such has access to a stable income through that source. Next, under Rule 46C2, a court should consider the nature of a defendant's family relationships, and under Rule 46C5, any individuals who agree to assist the defendant in their obligations with court. I believe these two factors are somewhat related, Your Honor, as a defendant's family relations in a community are often the same relations that that individual relies upon in giving this court assurance that it will comply with court conditions and orders and attend future court proceedings. When we look at some of those natures and ties, Your Honor, the defendant, being a local resident of the community, does have family located here in the Silver Valley. With that said, when we look at the nature of some of those relationships, we look first at the relationship between the defendant and his father, wherein his father has a lengthy criminal history and is currently on felony probation himself. Next, we look at the arguably most likely relationship which would secure the defendant's appearance in court in compliance with conditions, and that is their spousal relationship. In this instance, while the defendant's spouse does not have a significant criminal history, there is a recent charge as of 2019 wherein the defendant's spouse was charged with aggravated assault, and that case was ultimately resolved by way of a misdemeanor assault plea and violations of driving offenses. I think it's important to highlight in the course of that charge, which was just referenced, that the affidavit and the nature of the allegations in that complaint gave an indication from the defendant's spouse that a firearm or other dangerous weapon was used in the commission of that offense, and statements were made threatening violence. Next, under Rule 46C4, court should give consideration to a defendant's character and reputation. Likewise, under Rule 46C9, a court should give some consideration to a defendant's ties within the community, as those ties relate to a likelihood of flee upon release. As to the defendant's character and reputation, and any ties which would mitigate any consideration for a likelihood of fleeing, I'll defer to defense counsel if they have any factors they believe are pertinent for the court to consider under that provision. Next, Judge, Rule 46C7 asks the court to analyze a defendant's criminal history. When we look at the defendant's criminal history in this case, we see a sparse and sporadic criminal history which contains a number of violations between the dates of 2007 and the present. Analyzing some of those and outlining them for the court, as the court should be aware of what those are, I'll go through them in summary fashion and outline each which was identified either through a criminal history background check or through the I-Courts portal. In 2007, there was a no insurance and a fail to obey traffic devices infraction for which a conviction was entered. Also in 2007, there was a no insurance infraction. And finally, in 2007, an additional citation for failure to pay traffic violation fines. 2010, there was a misdemeanor charge with the nature of a battery. Ultimately, that misdemeanor offense was dismissed with no reason given within the criminal history printout. Secondarily, in 2010, there was a drug possession case. That case appears to have been resolved with a misdemeanor conviction. However, associated with that case is a 2012 probation violation, which was charged as a result of subsequent criminal charges out of jurisdiction. In 2012, there was a no insurance misdemeanor offense, which indicates a plea of guilty. And additionally, in 2012, there was a driver's license suspension violation for no insurance. 2014, we see another driver's license violation. In that case, we also see a misdemeanor plea being entered. And lastly, the most recent criminal conviction, as indicated on the criminal history, was a 2020 traffic infraction. A summary having been given of the defendant's criminal history, I'll defer to the court as to the weight or significance it places on any of those prior convictions or subsequent probation violations. Last, Judge, Idaho Criminal Rule 46C under subsection 6 asks this court to take a look at the nature of the offense and the likelihood of conviction. Although the defendant was cooperative with law enforcement at the time of initial contact, following their response to the scene of the incident, admissions were ultimately made to the offenses charged. In subsequent interviews by law enforcement with those in or around the scene, identified both a motive, a method, and a witness to at least 2 of the 4 charged murders. When we look at the significance of these allegations, Judge, we see under Idaho Code, each of them carries up to a life prison sentence and the possibility of death. 4 of those which could potentially carry that penalty and run consecutively, and a 5th charge of a felony nature as well. In the gamut of identifying the significance or seriousness of these offenses, Judge, Idaho Code does not contemplate a more significant offense. When we look at the actual facts of this case, Judge, we see a crime which was committed in a relatively horrific manner in regards to the nature of the allegations, the manner in which it was carried out, and the method that was utilized by the defendant in the course of his actions. Of importance to note, additionally, Judge, one of the 4 victims in this case was a child under the age of 18. All of those factors are pointed out to the court without going in great amount of detail to simply point the court to the nature of the offense and the likelihood of conviction, which should be considered by this court under the aforementioned rule. As such, Judge, and in summary to this court, should this court deem under Idaho Code 19-2903 that bail is in fact appropriate in this case and chooses to extend bail, I would ask that it be set at no less than $1 million. Thank you, Judge.
Thank you, Mr. Allen. Ms. Cheesebro.
Thank you, Your Honor. We're going to substantially defer to the court in this matter and reserve argument regarding bond. Before I do that, however, I think it's important for the court to know we are not in receipt of the affidavit in this case. Certainly those factors are laid out by the state, but we're not in possession of that yet. Secondly, I would note that Mr. Kaler has resided in Shoshone County his entire life. He is 31 years old. Lastly, I would just note that he does have minimal criminal history. Certainly the state's recitation seemed long, but in really breaking that down, we have a few misdemeanor offenses, certainly none of a violent nature. So with that, Your Honor, we are going to submit to the court. We are asking the court, however, to set a bond in this matter, and we'll reserve argument for a later time.
Thank you, Ms. Cheesebro. Whether or not to set a bond is in the court's discretion. Pursuant to Idaho Code 19816 and 192903, as well as Idaho Criminal Rule 46B, this particular defendant and the nature of the charges do not entitle the defendant to bond. Having heard the information here today, at this point in time, I am not going to set a bond in this case and will remand the defendant to custody with no bond, pending further information that the court will receive at future hearings to address a bond setting, with the defense having an opportunity to provide that additional information to the court. Is there anything else we need to address today, Mr. Allen?
Nothing further from the state. Thank you, Your Honor.
Ms. Cheesebro.
Your Honor, I just want to give the court a heads up. There will be a gag motion that will be filed by defense here in short order. We'll ask that be set for hearing, but anticipating that that will be brought shortly.
We will work on getting a court date for you as soon as possible with respect to that motion.
Thank you.
At this point in time, that concludes the first appearance for Mr. Kaler in CR 40-23-970. We will go off the record and be in recess.
And that wraps up the first appearance for the suspect in the Kellogg murders, where 4 people were killed.